Yes. Lord, in this case, my Lord, I seek your Lord's kind permission to file one application, Lord, because the reason is, Lord, that Lord, they have referred to Bhagwan Krishna to that consequential amendments and other subsequent steps taken in pursuance thereof shall also stand invalid. That is what Lord the petitioner has said. Now, Lord, what I have done, Lord, of the Supreme Court, Lord, I have taken copy of the entire Bhagwan Krishna's petition. And Lord, I have found out that what is the meaning of consequential amendment and other subsequent steps taken pursuant thereof. And it does not include appointment, my Lord.
I'm sorry, because this may not be relevant for today.
This complication is report. Then, Lord, I will argue the matter.
Mr. Kalra, you are Mr. Kalra.
Very well.
Please wait for your turn.
From the last occasion, we have actually been please go to the last order.
And that is what we are reading.
Yes, Lord. The Lordship said that we will await the judgment of the Honorable Supreme Court in an IA filed by the BA degree holders to say that those appointed should not be removed. On this basis, Maharaj, they have been seeking adjournment time and again, and therefore, your Lordship observed that if the application is not decided, it will be heard finally. Maharaj, fortunately, the application was dismissed by the Honorable Supreme Court by the very same bench which decided Devesh Sharma. The applications of the BOD holder
Where is the order?
You
You want to file what?
Lord, I want to file an IA whose permission, Lord, I am seeking from my
IA,
Lord.
IA for what?
Lord, this IA is for dismissal of the case. Total purpose is, Lord, that is Krishna because
You are appearing. You are appearing.
Lords, may I to appear?
Even Lord, who are BEd, who are working as primary school teachers. And my Lord, what my contention is.
Your clients are BEd degree holder and then they been appointed.
In March and all, we are appointed, we are serving. Now, our contention is, Lord, that the Supreme Court in Devesh Sharma's case, Lord, has saved those appointments, my Lord, which were done prior to 11/8/2023, and I am filing documents to that. Say,
My Lords, this is completely an incorrect statement. We have been appearing in Devesh Sharma, including in the matters taken up by the Supreme Court thereafter. And I must point out, the Honorable Supreme Court upheld the judgment passed by Rajasthan High Court.
Arora will come to you. Will come to you. Let them ask the
the other day, only one thing, Lord. Why I want to file this? The other friend on the other day was
Where is your application?
But it is not being filed as of now.
What is the prayer you are making for dismissal? All right.
One of the petitions, there are two petitions. One of the petitions is already rendered instructional.
Yes.
That is not easily case.
Yes.
On the last date also, we have produced the orders of appointment. These two petitioners have already been appointed as primary teachers. Their applications have been rendered instructional. Therefore, Mother, let us petition, that petition may kindly be dismissed as instruction because they have already been given appointment.
Yes.
Now they are misleading the court by saying.
Just one by one.
Even on the last date.
Now, Mr. Wilder, please clarify.
Yes.
You want dismissal of a particular petition because they are appointed. Who
Who
are appointed?
Kesri Rangan and Rohit Chaudhary.
They were diploma holders or they were?
They were the DLED candidates.
DLED.
Who filed the petition before this court.
Who is for the petitioner?
They are submitted.
Yes.
Before the appointments were made, the red petitions were filed challenging the notification of the NCP and the rules of the state to state that BA degree holders cannot be made eligible for level 1. Your lordship passed the order that all the appointments shall be subject to the outcome of the Devesh Sharma judgment, wherein the Rajasthan High Court judgment to say that the BA degree holders are not eligible is under challenge. Now, during the pendence of the petitions, appointments were made. Out of the bunch of the petition, in one of the petition, 2 petitioners have been given appointment. Rest of the petitioners
Here.
Alright.
This is what we have said.
Just to note that it is subject to final outcome. So unless final,
Devesh Sharma is finally decided, and it has been held, the holders are not eligible. One model There the consequences have to follow, must be notification and be filed. Please read the complete review, that something to see, they misread. Not much of it like this.
this is clear, just a minute. Your cause has become infectious or not?
No.
Yes.
But why not?
What the reason is my petitioners have not been given appointment. Only petitioners have been, rest of the petitioners who I am representing, they have not been given appointment.
How many petitioners are there?
Only two.
There are two petitions. Out of the petition. Yes, sir, बिल्कुल. Now, cases now and the petition में no petitioner है.
Has somebody produced appointment or not?
Last date में produce किया था Vipin Kumar Dwivedi, no one has been given appointment at the office. We are not talking about Vipin first cases number. Now I was telling you, we are talking now my writer was listed. They said we have looked at application one Arnav Ghosh state that all those appointments made prior to the notification should be safeguarded. The Honorable Supreme Court is safe with the matter. You are not the order that we can wait for that outcome. In case it is not being clarified, then we will proceed on merits. Fortunately, the application of the DI degree holders to remain in office only pretends that the appointments were prior to the order of the Honorable Supreme Court have been dismissed after hearing all the concerned parties. That order of 11/1/2023, 2024, we have placed it before your lawsuit with the compilation. Now, as entire things are very much clear, the Rajasthan High Court quest.
So we'll hear it.
No, we can put it to further, all the ground and we are moving this application for data. These are the two orders of appointment whereby the person in Kesri London, both the petitioners, he is talking about Vipin Kumar. He is appearing in Vipin Kumar. He has no say in the Kesri London. Kesri London case, both these appointments, these are the appointment orders, both the petitioners have been appointed. So let that first their petition be decided and then we'll address.
There are only two
Alonso,
petitioners.
I have something to say there. I don't think my learned friend can be really correct in that submission that he's making. Now, before my notes, there are three petitions as far as I can see.
Please one by one. I can't hear two learned counsel at the same time. Please.
Kindly have a look on these orders. These are the two orders whereby these two petitioners have been appointed. So let that first Kesri Nandan's case be decided.
My lord, we are having a very voluminous report.
Which is Kesri Nandan.
That is WC number.
Kesri Nandan, go on.
13768.
My learned friend can't oppose the dismissal of.
No, he has no say in the Kesri Nandan. He has no say in
Because
the
the exam order that all appointments shall be subject to the outcome of the Devesh Sharma was in the case.
He does not get the license.
Issuing London Madam, all other petitions for tax.
He does not
What
get.
they want is, the interim order of the appointment is subject to Devesh Sharma, so also.
Kesri Nandan is not rendered infructuous. You have no say in the matter.
Yes,
What was your prayer? Let us see. Kesri Nandan.
yes. My lords may have a look at the prayers in Kesri Nandan. I appear there.
The council of Kesri London will be, here's what, how it makes any difference.
No, you know, address of Kesri.
Ask can you see place 21 of Kesri London? Honorable Court may kindly please to include notification dated 28/6/2018 and 30/May/2018 issued by NCT making amendments under notification dated 23rd/August/2018 issued by MHRD Department of School Education Government of India. Thereby candidates pursuing qualification of B.Ed have been made eligible for the post of primary level teachers may kindly be declared illegal and arbitrary in ultra virus of the Constitution of India. And mandate of Article Act 2009 to appoint quality teachers and therefore should be kindly person satisfied. Thank you, Honorable.
The next prayer also, please. Yes, if you may please.
Again, the Honorable Court may kindly issue appropriate order or direction not to treat B.Ed candidates as eligible for the post of primary level teachers in schools under Article 2009.
These issues have been adjudicated now.
He is
Finally, by the Supreme Court.
Yes.
And you also seek appointment.
We also seek appointment.
That has been given.
Yes.
No, now there is a difference.
Oh.
The first petition petition was placed in, they lost to pass the order, and appointments have not taken place, but they shall be given appointment, all the persons selected, subject to outcome of the Devesh Sharma. Then came one of other petitions also, which were tagged to the lead file of Devesh Sharma, this case in London. Now, out of these bunch of the petitions, in case in London, there were petitioners who have now been given appointment. Now, whether these persons who have got appointment will make all other petitions infructuous for the reason, Manas, what they want to say is that if it is declared infructuous, the interim order of making all appointments applies to will also go. Now, in that case, we who are otherwise meritorious and have not been given appointment, Manas, will be ousted.
That
These
No,
persons.
we are only talking about one petition.
yes, we are talking about.
I appear in Kesari Nandan, may I have something to say there? And I think a lot has been said there without even hearing us out. My lords, first of all, my learned colleague there read the prayers.
Honorable court was waiting for clarification with respect to other matter.
And instead of going into all that, let us hear it from the.
Fine, not that.
My lords, may I make a submission, please, if my lords may allow me?
Your lordship can also assess, my lord, whether these two petitioners have accepted their appointment subject to their petition. They've unconditionally accepted it. Not so at least this petition cannot stand.
My lords,
Even
I am the
because this is the only
petitioner.
one which.
I am
filed
appearing for the
directly
petitioner. May I make some submissions?
So let us hear, let us hear the council who are appearing one by one.
Yes, so my lords, I appear for the petitioner. Let me make that first submission.
Which case are you appearing?
My lords, I am in Kesari Nandan, Saho. So now, my learned colleague present there before my lords read the prayers in Kesari Nandan. The prayers as have been made are in rem. They are on a larger principle on that particular notification, not to treat the B.Ed candidates and to grant liberty to the state to only treat BSTC candidates. Then they ask for an interim relief that any appointments to be so made will be subject to the outcome of what is decided there. Now, my lords have also granted that particular relief here. So the appointment, if any, made as on date is subject to the outcome what my lords will decide. It is very convenient to say, dismiss the petition without that particular confirmation, because tomorrow if my lords were to take a view which is different, I who have been appointed will be out. Now, I support this particular contention, and therefore my lords will need to authoritatively pronounce today. It is my respectful submission that on the last day, now every day there is a changing stand and a different positions that are being taken. On the last day before my lords will recollect, please take that order of 4th of January 2024. The objection that was sought to be taken to defer the hearings of this matter is that one application is pending before the Honorable Supreme Court in the Devesh Sharma matter to say that such persons having B.Ed degrees or whose processes had commenced at that point in time should be given the benefit of the appointments and they should not be disturbed. That was Arnab Ghosh application which was specifically cited before my lords. My lords may take a look at the order passed on 4th of January. I have a copy before me. And if I may just point that out, if I can read the first paragraph of that order, after hearing counsels for rival parties and facts which have been brought to the notice of this court, an application for clarification bearing number MA 2206 of 2023 is still pending consideration before Apex Court and is tentatively listed before a bench on 11 January 2024. As per the website, it would be appropriate to await the verdict of the Apex Court. Now, my lords, this application was relied upon because this application virtually said that all those who have been already, the process who has been commenced in respect of those B.Ed candidates, they may not be ousted. My lords, the registrar had dismissed, the application came up before the Supreme Court. The Honorable Supreme Court has since dismissed that application by its order. We have placed the convenience compilation before my lords where this order has been annexed. And if my colleague out there can just pass this convenient compilation to my lords.
Just one clarification here.
One minute, Ms. Mona. I am
just sorry to interject, my lord, but we have to clarify that this is not a case where they have been appointed. In Arnab, nobody has been appointed. That clarification needs to be stated before the court.
That-
Can't be not misleading.
Lord, that
My
much.
lords, may I just complete this?
Yeah,
Who is Kelsey Nandan to say all this?
Yes, Mr. Rupak, let
Either
them
he
complete.
say that she's representing some other
Let
client.
them complete. I cannot hear two persons at the same time. Let them complete one by one. Please complete your arguments, whatever you want.
Please, would my lords have seen the previous order passed on 4th January
You
and
are
now.
appearing for Kesari Nandan. You are appearing in.
I am appearing in the matter for Kesari Nandan, my lords, I am appearing in that.
So why has it not become infructuous, you are saying, because this.
For the simple reason that the appointment is subject to the final outcome, still, my lords will take the larger decision, all the three matters are connected, it is the
No,
same
final,
issue.
just a minute, final outcome in what?
My lord's final outcome in the present petitions, and all the three petitions are connected, they all raise the same issue.
Fine.
Yeah, they are on identical reliefs.
So,
And my lords have tagged all these matters together. So to say merely because Kesari Nandan has been today selected or is being given a letter of appointment, and that appointment is subject to my lord's order on subject to the outcome. Now, if my lords were to take a different view in the connected matters and it is said that my petition has become infructuous and my lords take a different view in the connected matters, I would stand to suffer a different position.
okay.
And in any case,
Just,
my prayers are
just a
prayer.
minute, just
My
a minute.
prayers.
Please, just a minute. Can we take a different view than the view of the apex court?
No, my lords, from the apex court, and
We can't.
that's exactly what I am requesting my lords to do.
So
I am requesting my lords,
the only question before this court is whether to oust the B.Ed candidates, appointees or not. That is all.
Yes.
We cannot take a different view so far as the issue decided by the Supreme Court is concerned. Please,
I am grateful. So my lords, so far as that aspect is concerned, I would like to bring to your notice that a large number of applications have been filed from time to time before the Honorable Supreme Court. I would request somebody to pass over that application, the compilation of orders, which are from the Supreme Court from time to time in diverse applications, including in fresh writ petitions where similar prayers have been made. And my lords, in each one of them, either after hearing the matters for some time, they have been withdrawn, or the same have been dismissed with cost in certain cases. Now, that convenience compilation, if my.
But my lords,
anyone out there-
We had tendered, my lords, got that compilation, it's a short compilation, it says time taken by the Honorable Supreme Court. There is a hard copy that my colleague has tendered in court.
No, I'm of the, we have the firm view that we cannot take a different decision.
Very well.
That has been
No,
taken by the
the-
My lords,
Supreme Court.
that compilation can be seen for.
That is the only question left is whether the B.Ed appointees are to be ousted or not ousted, that is all.
In fact, this has also been decided by the Honorable Supreme Court. That is what.
No,
This
I
has
am
been decided, my
so
lords.
sorry.
Please argue without matters, we are
So, my
hearing.
lords, therefore, if my may take the convenience compilation, I will show those orders, please. Allow me.
My humble request only is, not.
Lord.
Not.
My lords, the first order in that convenience compilation is Supreme Court in Bhagwan Krishna.
Not regard, because it places important documents, not, that's my total submission. Because Lord, my learned friend, has been harping upon the observation regarding consequential advertisements. Have demolished that not in this application for dismissal. Lord, please see this application, which copy of which I have given to my lord just now. Let it read the record and let.
You are for?
I'm for the proposed intervener, Lord, respondent, they can be proposed respondent.
Who are those? Who are your clients?
My client is not unsure.
No, and we are not about
We
names.
are
Appointees.
Lord, I am also here for some.
The question whether you should be in or out. That's all.
Lordship may hear us, Lord.
So may I, my lords, show those order sheets if my lords will permit me that?
Just a minute.
Yes.
Yes.
Some date because there has to be a compilation of what has happened, what has transpired in various states of the country.
Yes.
In some of the states, the appointments have been saved.
Yes, my lord.
That's a completely incorrect statement.
No,
Yes,
that's,
sir.
no, that is for the state government to come out.
Not in Calcutta,
It's
Bihar,
not, whether you are wanting to save them, and if you want to save them, then under what provision? Please tell us.
yes. No doubt.
Let's make a submission. The notification that allowed the B.Ed candidates to join, issued by NCTE, is under the central legislation. It's a central act. Now, the notification applies even if it is issued pan-India across the country, which makes B.Ed as an eligible. Now, that notification has been struck down by Rajasthan High Court, upheld by the Supreme Court. Once the notification that makes a qualification of B.Ed is not eligible for the purpose of appointment to primary teachers, issued under a central statute applicable across the country, my lords, it's not then
What
open
is
to
the,
anyone.
just a minute, what is the stand of the state?
They should be submitted a reply, most of the cases.
No, what is your stand? Whether the paid appointees are out or in, whether they, no, after the Supreme Court judgment, what do you maintain?
We are in.
After their appointment, and the appointment was much prior to the order passed.
Yes.
To the apex.
Fine, fine.
It was prior to the order passed. when
Fine.
the apex.
Now, do you want to save the appointments? And if you want to save them, then under what provision? And will that be at the cost of depriving somebody else who is more eligible, or in fact eligible? Then how would you accommodate, how would you,
May I just clarify that as
let's just see that.
Rules and then framed by the state government independently, those have never been otherwise, they were not subject matter of challenge before the office.
State rules will be subject to
Yes,
contract.
No, there is a very important distinction between may I submit, there is a very important
I'm sorry, Manoj, there is,
distinction between Devesh Sharma and the present case. That will have to be brought out, Manoj.
on the Devesh Sharma's case.
Let me-
Devesh Sharma's case. Devesh Sharma's case is the recital of.
Nobody was appointed in that case. In
But
this
so
case,
much of this
everybody-
court, I think it's better that you all don't want to argue the matter finally.
Our stand should be the record be of.
Please see. Devesh Sharma's case is the recital of.
No, please decide whether you want to argue or not. Has the state filed any reply?
This is the final.
They have filed petition also, which they are required to file.
There is a return, what return is of
AC number and some matter.
return of the interveners.
सर अगर आप 2 मिनट हमको सुन लें, हम ये बता रहे हैं, सर 2 मिनट अगर आप हमको सुन लें, सुप्रीम कोर्ट के जजमेंट की बार बार बात हो रही है देवेश शर्मा की केस। सर देवेश शर्मा का रिपरकशंस क्या है पहले देवेश शर्मा इज द रिसाइटर ऑफ लॉ। It only says that the candidates who were having B.Ed, they were ineligible and the persons having diploma were the eligible candidate. The matter was before the Supreme Court, the appointments made before during that period were before the Supreme. There are number of applications which have been filed to dislodge these persons who have B.Ed and who are appointed. There are number of applications. In none of the cases, let them produce even a single order where the Supreme Court has said that the appointments have already been made should be annulled. Now, every time they make an appellate.
That is why the matter was listed.
Therefore,
Why are you in that question?
what I am trying to submit is that it's not like this that the Supreme Court has something said in Devesh Sharma, therefore all appointments will go. ये बार-बार स्टेटमेंट देते हैं भगवान किसका भगवान किस एक मिनट इन्होंने भगवान किस
Devesh Sharma was the person who was applicant here only.
Please tell us whether you would like to argue the matter today or not.
Otherwise, we are.
one of the other state is saying
But may I make one thing for consideration of this court? There is a submission that I make and I think it has some relevance. My lords will appreciate one thing, that the notification of NCTE was struck down on 25th November 2021 by the Rajasthan High Court. 25th November 2021, no appointments of B.Ed could have been made at. Because it being,
Advocate, my lord.
No personal comments, please. Yes. So, no, we take it on record, there's no problem. But please tell us whether you are ready to argue or not.
Fellows, I am ready to go on if you would allow me. I'm for the petitioner and I think I have a right to be heard, my lords.
We all have. Case is pending since more than 1 year. He has not filed a reply in his last 1 year.
The reply is filed.
Where is the reply? I can't find a reply here. State government's reply.
It is there in our matter also. Vipin Kumar Dwivedi, they have filed a reply.
There's some reply of the intervener.
No, there is a reply by state also, my lord.
The connected case.
Yes, my lord. Vipin Kumar Dwivedi, I can see a
Which
copy by
case?
the state.
Sri Nandan में कहाँ है जवाब?
Kesari Nandan. Sorry, Kesari Nandan also. They filed it on 4th of December, my lord.
Return, there are two return.
Returned by
One is
respondents 3 to 5.
intervener, the other is
In fact, in one of them, it's filed subsequently. After filing our return.
this is respondent number 3 to 5. Who are 3 to
Yes.
5? Your return is there on it. Yes.
In 26.4, we did not file our.
They are all same. Yes. We are different. What is your stand? What is your stand in this return?
Stand your worship, that the appointments were made prior to the judgment passed by the in pursuance to the rules made by the.
What instruct
So
My lords, may I show the stand if my lords would like
Allow
to
them
see?
to place their square.
Paragraph 19 of the state's affidavit. My lords, that is why I mentioned that the Rajasthan High Court judgment is of 25th November 2021. And if my
We are
lords
talking
will
about
turn to paragraph 19, in Kesari Nandan, the reply of the state, the stand is clear. Please
My
see
friend is
paragraph
talking about
19
the
and
High
20.
Court judgment, my lord. Your lordships are asking about the Supreme Court judgment.
lords,
My lord. My friend is talking about the High Court judgment.
My lords, I don't understand this. A High Court quashed a notification. The Supreme Court only said no stay of the judgment, only subject to the outcome. The day the notification is quashed for the country because it's
I'm
under
sorry.
central legislation.
No,
This is
there has
not
been-
a state.
No, what have you
Miss
said
Mona,
about
can you
the
please argue
consequence of the
on the-
Supreme Court judgment? Where have you said in your return?
Correct.
What will happen after the Supreme Court judgment? What have you
My
got
lords,
in your stand on
The
that?
Supreme Court judgment upholds the quashing of that notification. Apropos
But,
to quashing of a notification which made B.Ed a qualification eligible for primary
But,
teachers, and B.Ed qualification
What
is
of your return? Where have you said this?
My lord, kindly
Yes,
put down
yes,
this
some-
paragraph 25.
My lord, I am on the fact of the appointments having made because today Supreme Court qualification is that they are no longer eligible.
My lord.
Para 21 now, the reply, my lord. Para 21. And also, there is also the Supreme Court.
Recently on 11th of January 2024, that application was rejected. That in that application an averment was made that the appointments made not prior to 11/8/2022 should also be quashed. So we want intervention, we want to put this point. The Supreme Court rejected that.
No, it was,
No.
Coach Malas.
11/1.
No, no.
Of course, was
11/1. I don't think it was misrepresenting the effect of that.
They wanted to quash, yeah.
Please argue the matter. All these points will be thrashed out.
So,
If you
So,
are
my lords-
inside the matter.
may I, on behalf of the petitioner in at least in Kesari Nandan, start my arguments, my lords, without my learned friends on the other side just interrupting.
Are you all with us in the final hearing aspect or not?
My lords, I want to start the final argument on this matter.
All right, we'll fix it tomorrow then.
All right. They will never,
Asking to at least tell us their stand.
And this paragraph number 23, that's the key from this slide. See, that considering the aforesaid things, the rules issued by the state of MP prescribing requisite funds, the primary teacher was never subject matter of challenge before the Honorable Court of Rajasthan, Honorable Apex Court selection and recruitment process has been
Correct.
appointed basis. And substantial number of candidates have already been duly appointed and working on their respective posts as primary teachers. In view of the aforesaid, unsettling the already settled position may not be in the interest of justice.
Yes.
For this, there's so many
Stand on record. Yes, stand there on record.
It's on record.
You want to say the appointments.
It's on record.
Plus, can we argue one by one, 10 minutes each, we can get and we'll put our point. Just give us 10 minutes to give. If the petitioner just take 10 minutes.
Today we have listed two matters as Passover which have to be finally heard. We'll take it up tomorrow.
May I make a prayer, Lord, if in case your lordships are not taking it up today, can it be next week?
No, because we are opposing that. We are opposing
Marcus,
that.
let it be tomorrow. Let it be tomorrow. Let it be tomorrow, my lords.
I'm only
Because
saying just
we are pending too long.
3 days accommodation, my lord, next week, anytime,
We
my
are
lord.
opposing that, because we are opposing that. We are vehemently opposing that.
Today we are ready.
In fact, this issue, Malos, whether B.Ed have to be out has also been decided by the Supreme Court in subsequent matters.
We also have our submissions to.
Tomorrow also we have a bunch of to be heard finally. So you can take your chance.
As, what we are requesting.
Very well, Lord. Very well, we take a chance, Lord.
We say no answer, not give it up. Okay.
That is what we had said last time.
Listen, no one is seeking for an adjournment. We are not
Say
taking the
that.
decision today.
Incorrect statement.
My lord,
I'm not case, please see the order. I just wanted to point it out, every time they made misleading is the candidacy or the announced in order dated
So
for.
we'll hear you tomorrow, Mr.
Yes, Lord.
See, if it is possible, hear it, otherwise we'll give you some other.
Very well, Lord. We'll take a chance. Oblige.
my lords, I only wish that as a petitioner, if I can be heard without being interrupted by the other side on the VC for barely 15-20 minutes, I'll be able to conclude my argument.
So tomorrow 3:30, will it be fine?
It would be very best.
I do that.
1 hour, you start with 1 hour, at least argue for 1 hour and then we'll,
Yes, my lord.
no, 15 now, we have some matters. Yesterday, tomorrow we have.
So that we will try to submit up with
We will give you 1 hour's time to start your arguments and to carry out whatever submission you have to make, and then if it's not possible at 4:30, then you might, it'll spill over to the next day.
Plus, can I just take 30 seconds by walk clock? Can I just take 30 seconds? Just 30 seconds.
But anyway, the matter is.
Can I just take 30 seconds? Because the prayer whether B.Ed prior to Supreme Court judgment are to be considered or not has been decided by the Supreme Court subsequently. And all of those applications have been
I'm sorry.
dismissed with costs. So
I'm sorry, my
Just
lord.
one second.
Can be
ma'am, if
argued,
you don't
my lord,
mind.
these have to be.
If you don't
I'm so
mind.
sorry.
If you
This is
don't mind.
incorrect.
If you don't mind. Please.
Completely incorrect.
don't
Okay,
mind,
please don't make that.
So all of those applications with prayer I have produced before my lord. Prayer is to regularize. And all of them have been dismissed with cost. The last one being day before yesterday. I have produced the prayer also before my lords.
And if the other side agrees.
We have objection, they never want this person to be
Because
observed.
the prayer,
Not
Sorry.
their petition, not your petition. We have to hear their petition. If, we'll seek a consent from them.
1.5 years, they didn't file the reply. Or when the lordship was to them, then they came up with the reply.
in fact, it is in their favor to seek an adjournment.
All those children.
Who is asking?
So, all right, due to paucity of time, let this case be taken up for the hearing tomorrow in motion at 3:30.
Oblige.
We'll see, sometimes these bunches get adjourned. We'll see. Time permits.
Well, could we give a short note as to who would argue so that it will be easier for us so that everyone doesn't speak at the same time tomorrow? Can we just put a short note that
We'll start with the petitioners. We'll start with the petitioners.
very well. Deeply great, Manoj, deeply great.
Oblige, my lord.
Number 20.